On behalf of Greenleaf Trust, I'd like to welcome everyone. Thank you for joining us. My name is Dan Rinsema. I'm the Chief Client Officer here at Greenleaf Trust. And you know, financial security from generation to generation is our company's motto. Always has been, always will be. And since we opened our doors about 23 years ago, we've been privileged to grow from about a handful of teammates to now over 150 talented professionals. We now serve on behalf of 1,200 families, foundations, endowments, and small businesses, and we've been entrusted with the oversight of assets that are now approaching $17 billion. And oftentimes I'm asked, Dan, why do you think Greenleaf Trust has been so successful? Why do you think you've grown at a rate that far exceeds that of the industry average? I often say I believe primarily it's because of our culture. We have an intentional culture focused first and foremost on our client. But in this context, we also understand the importance of closely partnering and collaboratively serving with that team of trusted advisors with which our clients surround themselves. And that's one of the reasons we're really excited that you've decided to join us this morning, as we bring out George Bearup, our Senior Legal Trust Advisor, who spent about 42 years or so in private practice as an estate planning attorney before joining the team here at Greenleaf. And today's presentation is really focused on what are those things over that 40-plus year career that George wishes he would have known then as a practicing attorney that he's found out now sitting on the side of a corporate trustee. And so we're going to bring out George in just a minute, but I want to let you know that today's recording in its entirety will be added to our website following the program. And while it is a live stream, you do have the ability to pause and rewind at any point if you need to. We're also going to have a Q&A at the end. There's a form below here that you'll be able to see. You can enter a question at any time for George. During the Q&A at the end, if George is not able to get to your specific question for whatever reason, we will try to email you and follow up with specifics there. So again, on behalf of my colleagues here at Greenleaf Trust, welcome. Thank you for joining us. We hope you enjoyed today's program.
So I was asked by somebody just before I presented, so what's the big change from going from a practicing attorney doing estate planning to working for a trust company? And the answer, the biggest thing that I remind myself of every day is you do not see a watch. The gift that I gave to myself on retiring the practice of law is I don't wear a watch, I don't look at a clock, I don't record my time, and it is empowering beyond belief to not have to keep track of my time each and every day for every 10 minutes of every day. So that's the big change that I encountered. So what are the big picture changes that I think that I'm going to ask? I always present what are the takeaways. You can go to sleep after you hear my takeaways, so you don't need to listen to anything more. The one that I think is the most important that I would ask lawyers, estate planning attorneys to seriously consider is that you are a partner with the trustee that you name in an instrument to carry out the intention of the settlor. We're partners. Sometimes I think when I was practicing law, I thought about the trustee that I was naming as a potential enemy. They may ask hard questions. They may make me look bad. And as a result, I confessed, I drafted a lot of trusts naming a corporate trustee, and the corporate trustee didn't have a clue they were named until the client died. And then the instrument was presented to the trustee. So my request would be that you seriously consider drafting a trust, and before it's signed, send a copy to the trustee and ask, is this okay? Can you live with this? Can you administer this? Are there any problems you see? Because of course, if there are problems, that means quite often that the trustee will go off to the probate court, petitioning the court for instructions, clarifying confusion, things along those lines. But that all translates into time and money. That's money that's taken away from the trust beneficiary. So the big request that I would have is that you send to the trustee in advance of actually having the document signed, the trust instrument, and asking if it's acceptable, if it will work, and if not, what changes might be made. The second thing I would recommend, and again, true confession time here, when the Michigan Trust Code was adopted in 2010, being an estate planning attorney, I committed to myself, I'm going to read that trust code. After all, it affects everything that I do. And of course, the best of intentions are, I think I made it through maybe 15 or 20 provisions in the trust code, reading it just because I felt that I needed to read it. And then of course, life came in, and all of a sudden clients had their requirements and their demands. And all of a sudden that best of intention to read the trust code from beginning to end never occurred. I would encourage you to find time or to make time to read the trust code. I mean, there are some kind of interesting provisions in there, you know, in the 700, 100 sections about defining what a trustee's duties are, how, you know, the knowledge that a trustee is imputed to have. Those are all kind of interesting provisions that I sort of stumbled into them as I was practicing law going forward. So I guess those are the 2 points that I would make is please provide a copy of the draft of the trust to the trustee in advance as opposed to a fait accompli. And secondly, find the time to read the trust code. It's got some interesting provisions in there that I didn't even know existed. Also, I would say to you as we begin, I'm not here to tell you how to practice law. I mean, that is the last thing in the world I want to do is tell somebody how to practice law. I can tell you that along the way, I'll tell you some of the mistakes I made practicing law. But the most important thing that I want to stress is that the trustee does something different than the drafting attorney does. The trustee administers the trust. An estate planning attorney has a client, the settlor, to carry out the settlor's intent. I'm kind of overstating this, but the trustee has multiple clients called trust beneficiaries. And so we're coming at this from an entirely different perspective. And so while a drafting attorney may feel like they have captured the settlor's intent in the words put on the piece of paper, coming at it from a different perspective is the trustee administering that trust for the benefit of multiple people, multiple individuals. There's an entirely different way to approach it. So something to keep in mind. The other thing that I found sort of as a big picture, I can't tell you how many times I had my clients sign their trust instruments, and I would always look at them before we, you know, the execution contract, right? Yes. All lying through their teeth. You know, they have plucked out the 2 or 3 sections that deal with who gets it, when do they get it, and how much do they get, and they don't read the rest of it. Unlike that, a trustee will read the trust instrument from front to back because the entire trust instrument contains the directions that the trustee is going to follow. And I think that it would be beneficial to provide a draft of the trust to the trustee prior to it being signed, because the trustee was actually going to read it from cover to cover and find potential inconsistencies or some ambiguities that could be clarified that would provide better guidance to the trustee. And again, presumably it would also benefit the beneficiaries. So it was, you know, usually when I was having the execution document or the document signing, I would also ask my clients, I say to them in advance, I'm going to give you a true and false questionnaire on what's in the trust. And the look on their face was just precious. I mean, I think one person almost had to go to the bathroom because they were going to throw up because, you know, I was going to test them on what was in their document. So they don't read it, but the trustee does, and that's a helpful pair of eyes for the attorney to catch any mistakes, catch any ambiguities in advance so that they can be fixed before the document is signed. Because the client, unless they're an engineer, engineers will read it from cover to cover and diagram the whole thing. But for non-engineer clients, they're just going to read 2 or 3 paragraphs and lie to you through their teeth and say they read it from cover to cover. So something to keep in mind. So what's the first big takeaway that I knew about it? I learned about it in law school. I was aware of it, but it never really totally registered for me until I was sort of in the administrative part of the trust. And that is, a trustee has a duty of impartiality. You know, when I was drafting trusts with my client sitting across the table from me, they were saying, okay, when I die, I want to take care of my spouse if they had a surviving spouse. I want to take care of the kids. And the focus was on if you will, the next generation. The children, when are they going to get it? How are they going to get it? Do we have any concerns about that? And then usually the lawyer, with always the what if question, would come back with, well, what if your child doesn't survive the data distribution? And then response is, well, then their share would go to their children, their descendants, per stirpes, and sort of like an afterthought. We're not really focusing on the grandchildren. We're really focusing on the kids, making sure that the kids get it in whatever manner or fashion that the settlor wanted. Well, so if you will, the focus of the drafting attorney is on the client and their child. I'm making that up, but that's pretty clear. In comes the trustee after the client dies. The trustee has a duty of impartiality to all trust beneficiaries, to the child, to the what if grandchildren, to the what if great grandchildren. And that duty of impartiality is significant from the standpoint that how distributions are made, how assets are managed, how investments are made. That duty of impartiality goes across the board. You know, one of the first problems that I encountered, or a question I should say, that a trust officer floated in front of me was that it was an irrevocable trust. Lifetime beneficiary is the child, then the assets are distributed on the child's death to the grandchildren. And the child was one of those, well, sort of a hippie type person. And the child did not want the trustee to invest in Amazon stock because, hey, they have a lot of trucks and planes flying around and we're creating a larger carbon footprint in society. And they were pretty adamant that they did not want the trustee to invest in Amazon stock, which seemed like a pretty good investment. And then you got the grandchildren who are alive and they're adults. Their mother's a hippie or whatever, and they're going, why aren't we investing more in Amazon stock? Well, the trustee has a duty of impartiality. We have to listen to the grandchildren and their thoughts on investment. We'll make the best decision and the best judgment that we can, but our duty extends beyond just the present beneficiary to other beneficiaries who are standing in line and someday will benefit from this trust. And so the message that I would share with you is that you can waive the duty of impartiality. That's one of the few fiduciary duties that under the Michigan Trust Code that can be waived, but it has to be clearly stated in the document. And sometimes you see that in trust instruments like the trustee shall primarily benefit my surviving spouse as long as he or she is alive and shall administer this trust primarily for their benefit, which is a nice way of saying focus on the first beneficiary and sort of like give afterthoughts to the secondary beneficiaries. Otherwise, the trustee's sitting there and sort of having to balance the needs and the desires of all trust beneficiaries, even though some of those beneficiaries are not currently benefiting from the instrument. The next one that I remember, and this one happened like 6 months into my sitting in a chair at Greenleaf Trust, and it had to do with, well, who's the trustee's client? And the trustee's client, no surprise, is the beneficiaries of the trust. So the situation was that dad, very wealthy dad, was a client of Greenleaf, and very wealthy dad created irrevocable trusts for his children. I think there were like 3 separate irrevocable trusts with a fair amount of assets in each of those trusts. And I got a call because dad called the trustee, Greenleaf, and said, this is how I want you to invest the assets for those trusts that I created for my kids. And it was a little awkward because dad had a lot of his own assets at Greenleaf, if you will, more assets than were in the trust for the grandchildren or for his children. And the question was, okay, when dad says jump, do we say how high? Or do we say to dad, gee, we appreciate your insights and your thoughts, but we'll be administering these trusts the way that we think is most appropriate for the benefit of the beneficiaries. The point that I'm trying to make is that once a settlor passes the assets on, I'm talking about primarily a lifetime irrevocable trust, dad's not a beneficiary of the trust. We don't really pay any attention to dad and dad's thoughts and opinions. Now, that's stupid. We do. I mean, dad's a client. We listen to them. But my point is that I don't ever recall in the irrevocable trust that I created for my clients, sitting with the client ahead of time and saying, you understand that once you part with dominion and control of these assets and they are transferred to an irrevocable trust, of which you say right here in this instrument, you've given up all power to amend or change, modify, or do anything with, that you have in fact given up control. And frankly, the trustee is not going to listen to you. Now, the trustee will listen to you, but we aren't going to dance to the tune that you play. So I say that from the standpoint that quite often I feel like, again, the drafting attorney, I set trustees up for the old let's kill the messenger routine, because nobody wants to sit down with the trustee and say, go away, we're not going to listen to you. After all, he's the one or she's the one that transferred all the assets to the trust. But it's something to keep in mind that if you are going to fund an irrevocable trust on behalf of a client, you probably need to have more than just a passing reference to, oh, you understand this is going to be irrevocable, and kind of move on to the next topic. You need to pause and say, this is what this means. This means that the trustee has a fiduciary duty to the beneficiaries of the trust and not to you. And they will administer this trust in a way that is in the best interest of the beneficiaries, not necessarily what you want the trustee to do. It was an interesting question to learn. The next point that I would, this is one that I used when I gave speeches for ICLE, I used to harp on this, I still harp on it, is that I'm surprised at the number of trusts that I review that there is no reference in the trust to what the purpose of the trust is. I mean, we quite often we tell our clients, well, we're going to have a trust, and by putting all your assets or retitling your assets in the name of the trust, you'll avoid probate, which is a good thing because of the expense, delay, and publicity associated with probate. That all makes sense. But what's the purpose of this trust? You look at the Michigan Trust Code, and several of the provisions in the Michigan Trust Code refer to the material purpose of the trust. For example, if you go to the probate court and ask the probate court to modify the terms of the trust, that section of the trust code says that the trustee or the probate judge may make a modification of the trust if it doesn't affect the material purposes of the trust. So if there's no material purpose in the trust, like a provision spelled out for whatever it is, it's kind of like an Easter egg hunt by the trustee, kind of reading all the trust and reading between the lines and, you know, the engineering diagram, trying to figure out, okay, what's the primary purpose of this trust? A simple example is probably 98% of the trusts that I see have a spendthrift provision. Well, is that a material purpose? Or is it just a throwaway provision because it's in every boilerplate in every trust that you've ever seen? Is that a material purpose? And I raise that because there was a case, not in Michigan, in Nebraska, just a couple of years ago, where they went into the probate court to modify the terms of the trust, and the judge refused a modification, even though all the trust beneficiaries agreed to the modification because there was a spendthrift provision in there. Now, I don't know if I would agree with the probate judge in Nebraska on that, but the point being that if we start talking, and we always talk about how we want to make trusts more flexible and adaptable to the changing circumstances of beneficiaries and law changes, and we may want to run into the probate court and have the trust modified to reflect those changes, all of a sudden you've got a spendthrift provision in the boilerplate that, of course, nobody read, but there it sits. And does that preclude the ability to make a modification of the trust? My point in saying all of this is that I strongly encourage lawyers who are drafting trusts to put in a material purpose. The material purpose of this trust is to preserve assets and to protect them from creditor claims against my child, and in the event that my child ever goes through a divorce. That's the material purpose of the trust, as opposed to trying to search and think intuitively, try to figure out what the purpose was behind the settler creating this trust. I would say that in my final years of practicing law, one of the things that I asked my clients to do was to try their hand at having them write out a material purpose. What do you intend to accomplish? What's the purpose behind this trust? Now, I would ultimately take their written work product and sort of lawyer it up a little bit. But the point being is I wanted them to share with me what they thought the purpose was behind using a trust, that if particularly those kinds of trusts that are going to hold assets back from individual beneficiaries for a period of time. Many clients, frankly, I never had a client sort of complain and say, well, you're the lawyer, you're supposed to be drafting this, why are you making me work on my own trust? But I think it's important that we try to engage our clients a bit more in what is, I think, an important aspect. What is the purpose for the trust? The next one that I always thought was kind of, and we've covered this already to a degree, is the boilerplate provisions. The Michigan Trust Code very clearly says that a trustee must administer the trust according to its terms. It doesn't simply say those paragraphs that deal with who gets it, when do they get it, and how much do they get. It says the trust's terms. So if the trust is 40 pages long, each one of those is part of the terms of the trust, which gets back to, again, the trustee having to read the trust instrument from cover to cover. And what I've learned at Greenleaf, and I'm sure most other trust institutions as well, is that then the key provisions of the trust, all 40 pages of it, are summarized by the trust officers so that when they meet with their clients each and every year, they have an opportunity to kind of get an up-to-date remembrance of what the terms of the trust were. So remember too that there are much of the Michigan Trust Code, which governs the trustee, are default provisions. You can opt out of many of those provisions. But this is where I'm talking about proofreading the trust, where you get some sort of sometimes confusion. For example, the trust instrument in the boilerplate might not say, but it might say the trustee shall be governed by the Uniform Principal and Income Act. And then buried in the document, there's a provision that says the trustee shall treat capital gains as income. Well, that's inconsistent with the Uniform Principal and Income Act. So you now have an inconsistency in there. And then it's up to the trustee to try to figure out, okay, does this mean that we're overriding the Uniform Principal and Income Act, and it's going to be a default provision that we can avoid and ignore? Or are we somehow going to have to reconcile these two provisions? Point being, again, we're looking for, not that the trustee is looking for inconsistencies, but when it runs across an inconsistency, it needs to reconcile those two. And if it can't, and it may be a big ticket decision that has to be made, the trustee will run off to the probate court, not making trust beneficiaries happy, because the trustee is then incurring legal fees, money that would be generating income for the beneficiaries. We're looking to the probate judge to help us describe it. The next one that sort of an interesting one, this is one where my perceptions changed. When I was drafting trusts, I bought into the flexibility. We wanted to make that trust as flexible as we could. And then you look at all the tools that are available under the Michigan Trust Code now with, a trustee can disclaim assets. Stop and think about that for a second. So John creates an irrevocable trust for his kids, and somebody else John's brother wants to transfer assets into the irrevocable trust for the kids, and the trustee says, oh no, we don't want those assets. We're going to disclaim that gift that came into the trust. Stop and think about that. How many trustees who have a fiduciary duty to administer the trust in the best interest of the trust beneficiaries would turn away assets? Not very many of them would. Now, if it was a contaminated gas station, maybe. But if it's a portfolio of Amazon stock, oh, no, we don't want Amazon stock. No way at all. That makes no sense. So while a trustee has the authority to disclaim assets, that's somewhat of kind of an illusory power that won't be used very often. Same thing would apply with a decanting. More and more clients who talk to their lawyers and who also read now are aware of the fact that trustees can not decant assets from one trust to another trust. Particularly those beneficiaries come in and say, my brother's drinking too much. Why don't you decant the assets so that my brother doesn't get any assets? To basically remove my brother from the next trust. Trustees are not inclined to exercise these flexible powers that the trust code provides. A lot of lawyers think that they do. A lot of lawyers draft them thinking that, well, if I'm a little sloppy in what I phrased, the trustee can always go in and modify the trust, or the trustee can terminate the trust, or the trustee can decant the trust assets. It's not that simple. And so if you really want to give, I mean, basically the trustee is going to be reluctant to run off to probate court to change the terms of the trust. They will if there's a problem, but they're reluctant to do so. So I think that if you are drafting a trust and the settlers talk about and likes the idea that the trustee might be adapted and modified to reflect circumstantial changes of the beneficiary or tax law changes, you might want to spell out in the trust document to the trustee, it's okay to decant the assets. And in fact, you've heard me say this before, you know, Michigan's decanting statute requires a 63-day notice before the trustee exercises the power to decant. Well, that's what the statute provides. You can have your own decanting provision put into the trust if you wanted to, dispensing with the 63-day notice. There are a lot of things you can do. So my point being simply that while we talk about flexibility in the Michigan Trust Code gives the trustee plenty of flexibility to do a lot of things, I think most professional trustees are going to be very reluctant to embrace those changes and opportunities simply because of the delay, the expense, and frankly, the thought that if you're going off to probate court, guess what? That trust isn't going to be confidential any longer. It's going to be a matter of public record. So a trustee is going to be very reluctant to exercise those remedies. Another point where I was brought in, and this one the law is not helping us any. And that's we're seeing more and more discretionary trusts because discretionary trusts are creditor. They're very friendly to beneficiaries against creditors. You see that also with dynasty type trusts. So we're seeing more discretionary trusts. And the question then becomes one of what does the trustee take into consideration in exercising its discretion to make a distribution from the trust? And this gets into what are the other financial resources that are available to the beneficiary that the trustee would take into consideration. Where the law is not helpful, and I know I'm sounding like a broken record for those of you who have sat through these before, if you read the Restatement Third of Trust written by law professors who claim that they are summarizing common law, which I don't believe they are. I think they're doing this is what the law ought to be. They say that a trustee shall take into consideration any other financial resources available to the beneficiary before making a discretionary distribution. If you look at the Restatement Second of Trusts, which was an older version, it was very clear that you do not take into consideration the other financial resources available to the beneficiary when making a discretionary distribution. So what is it? Does a trustee take other resources into consideration or not? Many trusts are silent. They just talk about discretion of the trustee, kind of leaving the trustee hanging there, kind of figuring, okay, do I automatically decide the Restatement Third applies because, hey, that's the more recent version, or do I say the Restatement Second applies? Michigan Trust Code does not expressly address this. So my point being is if you're drafting a discretionary trust and you're planning on the trustee taking into consideration other financial resource, go ahead and say it in the trust instrument. And what is a financial resource? Is it the equity in a home where you have to, you don't need a discretionary distribution, you can go get a line of credit against the equity in your home? Or is it only liquid assets as opposed to illiquid assets that constitute a financial resource? Something to consider and keep in mind as you go forward. Briefly, I'll just simply say, many times trust instruments contain words of degree like what is necessary, what is appropriate. I mean, Greenleaf, and I'm sure all trust companies have a trust committee that sort of sit there and decide, particularly when a trustee is being asked to exercise discretion in making a distribution. I'm not sure when the trust instrument says what is necessary or what is appropriate. Those are kind of subjective terms of art. They aren't really helping advance and make it very clear to the trust committee whether a distribution should be made. I would be helpful in that situation if you're using words, I'll call them subjective terms of art, to either use examples in the trust instrument. That's fine to use an example, or to use, I call them letters of wishes. Other people call them other things, but it's sort of a companion precatory letter that accompanies the trust that says, this is kind of how I'm envisioning this trust being administered. These are the kinds of things that I think would be an appropriate distribution to my kid or my grandchild. Those are extremely helpful. They're not binding on anybody, but trust me, trust committees that agonize over discretionary distributions, any help is better than no help at all. Another area a topic that I have found of some interest, not too many of them, these are, I call them incentive trusts, where the child is a spendthrift and we want to use the trust to correct their spendthrift ways, or a beneficiary has a substance abuse problem and the trust is going to be used to help them get help, rehabilitation, any kind of incenting of a behavior, encouraging them to go get an education or things of that sort. That oftentimes requires the trustee to monitor the trust beneficiary. Well, that kind of begs the question, what is contemplated by monitoring? Does that mean a weekly phone call from your friendly trust officer? How are you doing at home today? Does it mean every calendar quarter you have a face-to-face meeting with the beneficiary to see in your own mind whether or not they're still using drugs or alcohol? In an incentive trust, that usually entails some form of monitoring by the trustee of the trust beneficiary. What's the frequency of the monitoring? And oh, by the way, is it okay to spend a lot of money? I mean, we may have to send the kid off, the beneficiary off for a blood test every 30 days. That costs money, takes time. I think a lot of people like the idea of an incentive trust or a trust that requires the trustee to monitor the beneficiary, but not a lot of thought goes into what does that really entail, and are we prepared to spend the kind of money that may be involved in facilitating that monitoring. So I raised from the standpoint that what is getting back to the trustee's responsibility, what is the trustee's responsibility to inquire or monitor the beneficiary? I mean, you look at the trust code, back to the early sections of the Michigan Trust Code that no one ever reads or until you have a problem. And it talks about the actual knowledge of the trustee. When does the trustee presume to have actual knowledge? And there's no duty, while the trustee has essentially no duty to inquire. By the same token, if you're using an incentive trust where the trustee is sort of involved in a monitoring role, by default, there is some form of duty to inquire. But what is the settlor contemplating the trustee doing? And the more direction you can provide in that, the better, because the trustee is not all-knowing. Next one, full disclosure. I apologize to my clients. When we first came up with the trust protector concept, I bought into it whole hog. I mean, I just thought this was the greatest thing. If I screwed up drafting the trust, I always had a trust protector there who could sweep in and amend the trust like a Marvel superhero and fix the problem. And so my trust protector provisions went on from 2 and 3 pages, because I was, if I needed this, we could give them this power and this power and this power. I sometimes look at trust now and say, why do we have a trust protector, or now a trust director provision, when the trust says, as soon as practical after I die, muster the assets and distribute them to the children? Okay, we're not going to run the trust for more than a year, maybe, and it's all going to be tied up in administration anyway in that year. Why are we using a trust protector provision? You know, the one that I read last week was only 7 pages long. And at the end of it, I was sort of scratching my head, kind of going, a lot of the powers that we gave to the trust director were the exact same powers that we gave to the trustee. And so I'm thinking, okay, who wins in this battle? You know, I'm going to amend the trust. Well, I'm going to amend it back. Well, I'm going to do this. Well, no, I'm going to take it back. I mean, so the point is that first, don't overuse a trust director provision unless, first off, I think if you're going to have a longer term trust, it's going to be administered for a significant period of time, then yeah, a trust director would be appropriate. But then secondly, why are we using a trust protector? What is the specific purpose? That may be managing an asset, it may be making distributions to the trust beneficiaries, but try to narrow it down so that there's less of an overlap of powers, because part of the Michigan Trust Code, when you're creating a trust director and giving that trust director power, the statute also says that that trust director will have unspecified further powers. Well, that's really helpful, because most trust directors think those unspecified further powers means that they can do whatever they want to do. Well, not necessarily. So the point being is that if you're going to use a trust director provision, think thoughtfully about what is their purpose, why are they going to be involved, and make sure that there's no overlap or confusion in the powers given between the trust beneficiaries. The next one that, and I'm probably going to sound like I'm a shill for Greenleaf, I guess I am, but is co-trustees. Well, I'm going to name Greenleaf and my adult son as a co-trustee of this trust. Question: why? What's your son going to do? The Michigan Trust Code is pretty clear. Co-trustees act on a majority vote. So if you have two trustees, by default, that means you got to have a unanimous vote of the two trustees. And what happens if, in the one case where I was brought in, I answered the question, but the co-trustee, the individual co-trustee, went to Africa on a safari for 6 weeks, and a decision had to be made. And the trust code says very clearly that the other trustee, Greenleaf, has to make reasonable effort to contact the other trustee to engage them in the decision-making process. Well, we couldn't reach that other trustee, the co-trustee. And again, the only reason that co-trustee was named was apparently mom and dad thought that they needed to have their son act as a check and a balance on Greenleaf going rogue. I don't think Greenleaf would ever go rogue, but that was, I guess, their thinking. My thought would be just name Greenleaf and give your kid the power to remove Greenleaf without cause. If you really want to check, give them the check to fire Greenleaf if they don't think Greenleaf's doing the job. As opposed to naming them as a co-trustee where you're going to spend a lot of time and energy and incur delays in making decisions as you chase down the other co-trustee to get their consent to whatever kind of decision is being made. Just briefly on HIPAA releases, anytime you're dealing with an incentive trust that deals with the health of the beneficiary, or you're dealing with a trust settlor who maybe it's a revocable trust and the successor trustee is a Greenleaf, and the successor trustee is told you can remove the acting settlor trustee if they become incapacitated. Well, how does Greenleaf go about getting information about the settlor's incapacity? Does it have the right to access medical information? It's a small matter. Same thing with a trust beneficiary for whom health support or maintenance distributions are being made. Does Greenleaf have the right to access the medical information of the beneficiary? That actually happened where, it's a discretionary distribution and Greenleaf wanted to know the health condition of the beneficiary and the beneficiary refused to give any medical information. So Greenleaf says, well, I guess if you're not going to help us with the information, I guess we won't be making a distribution to you, which of course angered the beneficiary because it was none of our business what their health was like. So you get into that kind of a situation. It would be more empowering if you actually spelled out and required the beneficiary in that situation to provide medical information, including a HIPAA release, which would give the trustee the ability to gain any medical information, just not that which the beneficiary chose to give to the trustee. Tangible personal property. We all know that as lawyers, that's where the problems lie. It's not with the big ticket assets. It's who gets mom's china set, who gets mom's diamond ring. And kind of the question that cropped up was that Greenleaf was named as a trustee, and Dad died. Dad was the surviving spouse. And for whatever reason, I'm not quite sure, the daughter had one of Dad's antiques in her home. And so the trustee said, well, we're going to need you to bring back that antique so we can get it appraised, because we have some responsibilities and debts to pay and whatnot. And the kid said, no, I'm not going to give it to you because it's earmarked for me as a specific bequest anyway under the terms of the trust. So no, I'm not going to turn the antique over to you. Small matter, but it's an important matter. And so we spent a lot of time wrestling with the beneficiary, who we're trying to keep a good relationship with, I might add, by saying, no, you need to give us the antique so that we can get it appraised and we'll get it insured and we'll get it right back to you as soon as we can. No, I don't want you to take the antique. Point being is that how do you deal with that in a trust instrument? And the way that I think is the best way is in the trust instrument, because tangible personal property, candidly, is seldom in the trust. It may be titled in the trust, but it's in somebody else's possession somewhere else. And usually the kids, between the showing at the funeral home and the funeral service itself, are hitting mom and dad's home, taking all the valuable items, because they're convinced that every thief in northern Michigan is going to hit the decedent's parents' house and ransack it and take all the valuable stuff. So they put it in the trunk of their car for safekeeping, and we never see it again. So the point is that it might be helpful to say in the trust instrument that all of those persons who are in possession of the decedent's tangible personal property, furniture, antiques, jewelry, whatever, that they are special trustees. We basically anoint them as a fiduciary and impose upon them fiduciary duties, which makes them hopefully sit up and think a little bit more closely about what they're doing with the assets if they're acting in a fiduciary role. They won't understand it until the lawyer or the trustee can explain it to them. Next one that I think is a real problem, again, true story. Of course, you'll never know if any of my stories are true or not, but they are true stories, which I was brought in when a beneficiary of a discretionary trust at Greenleaf already had a loan outstanding, and they were asking for another loan. Not a distribution, a loan. If you look at the trust code, one of the one of the specified powers that a trustee has under the trust code is to make loans, even to a trust beneficiary. The awkward part was the trustee or the trust beneficiary had made no effort to make a repayment on the first loan, and they were back for a second one. And the way the trust was written, they probably wouldn't qualify for a discretionary distribution. So how do we skin this cat? Well, we'll just take for a loan. Of course, never expecting to repay the loan later on. Added to that was the reality that there was a spendthrift clause in the trust, which prohibited the trust beneficiary from assigning, in this case, his interest in the trust. Well, how does Greenleaf take security for a loan if you can't get your hands on or legitimately have the beneficiary pledge their interest in the trust to assure repayment? My point in that is that if the trust settlor wants the trustee to have the power to make loans, it would be helpful to spell out what are the terms of the loans. Can you have multiple loans outstanding at any one time? What are the terms of repayment of that loan? Again, are we trying to make the trust beneficiary responsible? We want to help them out with a loan, but it's a loan. It's supposed to be coming back at some point in time. Not to mention that you have other beneficiaries standing in the wings who may not be real happy with 3 or 4 outstanding loans that were never repaid to the trust that they're ultimately going to presumably receive the assets. So you have to deal with that. And if you're going to have a spendthrift clause, you might want to carve out an exception on the ability to make loans and to pledge assets of the trust if that's something that the settlor wants. Another issue that I see, and this is, again, this may be more of a hot button for me, going back to when I was practicing law, the income only. This trust shall pay all the income to my daughter for her lifetime, and on my daughter's death, the assets shall be distributed to my grandchildren. Well, an income only trust these days doesn't pay very much. Now, a trustee under the Michigan Uniform Principal and Income Act has the power to adjust, so you can classify some principal as income, but that's an annual, every year determination. So the trustee being asked to exercise its power to adjust will adjust, and if you will, invade principal, call it income, and make the distribution. But there's a whale of a lot of work involved in making that determination. And the trustee's got to document this decision. And if you look at the Uniform Principal and Income Act, it talks about the trustee taking all factors into consideration and making that power to adjust decision. So my hot button is, in this period of low interest, although that may be changing with inflation coming back, what we're talking about is perhaps creating a uni trust from the get-go. Rather than saying income and principal, why don't we just simply say, pay the trust beneficiary 5% of the trust assets each and every year. The distribution out to the trust beneficiary will carry whatever income there was, and then anything above that will be trust principal. It's much easier, and talking with trust beneficiaries, they like that, because they can budget it. We do a snapshot on December 31st, and we say, you're going to get 5% of that amount over the next year, paid in monthly or quarterly or whatever it is, and that enables the beneficiary to more competently budget what their expectations are from the trust going forward. Now, Michigan is currently considering adopting the Uniform Fiduciary Income and Principal Act, which is the most recent version of the Uniform Principal and Income Act. And again, if it adopts it the way it's written, we would also have the ability for the trustee to make a one-time determination shifting from an income only to a uni trust, and then we don't have to do all that busy work each and every year thereafter. So it's something to keep in mind, but if you're talking about drafting a trust with income distributions, you might want to consider a uni trust distribution, because it's better for the trust beneficiary, I believe, and it's much easier for the fiduciary to administer. The next topic, and I guess maybe we're at the last one, I've skipped over a few, but no contest provisions, the in terrorem clause. In Michigan, you can have them in a will or a trust, but if the challenger has probable cause to challenge the validity of the instrument, then it's not going to be binding, and they're not going to forfeit their interest under the will or the trust because they filed the challenge. In reading them, again, many of them go on for pages. I guess, people are worried about probate litigation. They're worried about, clients are worried about somebody coming in and destroying their estate plan or holding people up, holding the estate, if you will, hostage while they challenge the validity of the instrument. I think the problem is many of these clauses that are drafted go beyond just challenging the validity of the trust, because the statute in Michigan talks about or any other proceeding that affects the trust. Well, that's a little vague. So if you have a valid trust that's being administered by the trustee, and a trust beneficiary wants information about the trust being administered, maybe they're a contingent beneficiary down the road, but they still want to know what's going on under the trust, and the trustee has a responsibility to answer reasonable requests about information with regard to the trust. Does that constitute, does that trigger the no contest clause? I mean, many beneficiaries are looking to the trustee to act as a policeman. That's a violation of the no contest clause, because they wanted information about the trust, and they're not entitled to information about the trust. So we want you to file a proceeding with the probate court to disinherit that beneficiary. They're kind of putting the trustee in the spot of being the mean person trying to disinherit somebody. So you look at these trust provisions, or these provisions, I call them the no contest provisions, and they're broadly drafted. Anybody who snarls at the trustee shall forfeit their interest in the trust. Well, that's not what the law is intended to accomplish. But yet, that's how many of these no contest provisions are being drafted, to cause the trustee to be, as I say, a policeman, causing or threatening to disinherit some people. Last topic, because this one just came up. This one just came up a month ago. So you have a trust, big trust, a lot of assets. The settlor died. We're now administering the trust. And then the trust is written, so it's going to fund a credit shelter trust and a marital trust later on. And the trust instrument says, I'm paraphrasing, upon my death, the trustee shall pay to my surviving spouse $5,000 each month. Okay, pretty simple, right? Well, we're dealing with the administration of the trust. We haven't funded the credit shelter trust yet. We haven't funded the marital trust yet. We're still dealing with paying estate expenses, getting appraisals, dealing with whether or not to file an estate tax return. So everything, I call this as an administrative trust. We're still dealing with the administration. We haven't yet funded the subtrusts. The question is, does the beneficiary, the surviving spouse, get $5,000 a month? Or does the beneficiary get nothing until the other trusts are funded? So it's a simple matter. You know, I called the estate settlement people at Greenleaf and they said, no, no distribution of $5,000 until the estate is settled. Debts are paid. And I'm thinking, I'm not sure that's what our settlor was intending when they said pay $5,000 a month to my surviving spouse. You can clarify that and just simply say, even during a period of administration, the trustee shall pay to my surviving spouse $5,000, and then we'll figure out the mechanics and the allocation at the end. So with that, I'm through with my comments, and I would open that up to any questions other than John, who can't ask questions because he's holding his head. That scares me when you're holding your head, John.
I was just itching my forehead.
Thank God for that. Okay. Any questions?
So I understand like your comments about the dichotomy of asking or assigning a co-trustee to a trust, but when would it be best to add a co-trustee to there?
The question, I think, has to do with when would be the appropriate occasion or time or circumstances where it would be appropriate to name an individual to act as a co-trustee with a, if you will, a corporate trustee like Greenleaf. I would think that particularly if a trust beneficiary has unique situation, you know, maybe they have, if you will, mental issues, they have concerns, they're very fragile type of beneficiaries, where there might be a sibling of the beneficiary who is fully understands the needs and maybe what are the hot buttons and where to stay away from topics like that. I think that would be an appropriate time where you could name a co-trustee. As a child, I would more likely say, why don't you name that child as a trust director to make distributions to or on behalf of the beneficiary and leave, if you will, the investments and the other administrative decisions to the corporate trustee. But that would be a situation where I think having a person who with intimate knowledge of the needs and welfare of the beneficiary might actually be a better than a Greenleaf corporate trustee. Other questions? John?
I don't have a question, but an observation from the many years that I've been doing this. And when I started out, I drafted a lot of common pot trusts for families on the theory that if somebody dies, then with children, then they've got some children are older than other children, and they've had access to the parents' funds for a longer period of time than the younger ones have. And so by making it a common pot, then that sort of makes up for that by allowing maybe a greater amount to be spent on a younger child than on an older child. But then I started running into cases where common pots were being abused by people, you know, the stoner in the family, or the shiftless one, and was asking for more than what they wanted, or more than their fair share. They wanted it. No beneficiary ever gets enough, so they wanted more than what essentially their share. And the other kids in the family were saying, "Whoa, wait a minute!" And they were starting to make objections to trustees about what they were doing. And it was an awakening to me to find out, you know, in the long run, it really is better off to cut out shares for each person.
So John's comment was, you might think twice before using a pot trust because it can be abused by stoners
Well, and we got,
or black sheep. What about, I mean, John, could you have a pot trust, but then add some advancement language that says, distributions beyond what other beneficiaries receive from the pot will be treated as an advancement at the time that's finally divided into shares?
and you do that, and the math surprisingly is not difficult to do. I've had situations where advancements were provided to kids, and then trying to figure out what actually their share was after you take the advancements into consideration, which that's money that's outside the trust now. I mean, it's gone.
Right.
So, but you got to add it back in.
Okay.
And surprisingly, the math is not as difficult as you think it might be.
So consider if you're using a pot trust to also consider possibly adding to that a provision dealing with advancements. I'm not sure every expenditure would be treated as an advancement, like payment of health insurance premiums, but distributions for a car might be treated as an advancement.
Especially if it's a red Camaro.
A red Camaro. Okay. Other question.
One of the bigger problems is that families, and this happens more often with families of more modest means than families with more means. And that is that they end up having provided benefits to one of several children that is greater than that, or it's about to be greater than that person's share of the pot at the end. And I'm always surprised that people don't seem to remember, grade school math about stuff. It's just amazing how troublesome those can be. And boy, kids, they remember grade school math.
Kids keep score, no matter how old they are. Nathan?
I have a question about notice. So something I worry about a little bit in my drafting practice is if I'm actually constraining notice in a way that's going to cause problems for the successor trustee. So under the NPC, after the death or when the settler becomes disabled in a rep trust situation, if you're supposed to be giving information about the administration of the trust and the reports. Well, so if you try to define down who's entitled to notice, is there a point where that actually becomes problematic for you? You say, boy, we're just going to be providing reports to beneficiaries, even if the instrument has, defined down who gets notice.
So the question is, in situations either like a disabled settler of a revocable trust, so the successor trustee now has to provide notice to others beyond the settlor who's incapacitated. How far down the road do you go in providing that notice? That again is sort of I don't think the trust code accurately tells us how far down the line you go. Clearly qualified trust beneficiaries are going to get information about the trust. But beyond that, what about the settlor named the church to get a $10,000 distribution? Do we start giving reports to the church when we may never have enough money to fulfill that charitable bequest at a later point in time? There's no good answer to that. It would be helpful, I suppose, that if a trust instrument said only provide information with regard to this trust to qualified trust beneficiaries if I later become incapacitated. I think that would provide sufficient cover, if you will, for the trustee.
But if I say, for example, the accounting beneficiaries are going to be the beneficiaries of income, and trustee, you don't have obligation to give notice to the remainder of them. I mean, does that create more of a problem for you, or is it beneficial?
I would think that the response was, can we kind of cut it off at some point in time, if you will, arbitrarily cut off? Where do we stop giving notice? Does that create a problem for the trustee? Or is it beneficial for the trustee? I would think that from the trustee's perspective, it would be better to have a clear, bright line where we stop giving information. If others beyond that line think that the trustee is abusing their discretion, the trustee can always point to the provision in the trust and say, we're just following what the settlor directed us to do.
Well, the problem with the current income beneficiary is, the current income beneficiary is the current income beneficiary because that's the only person you're paying it to. Or the current income beneficiary is the person who you might possibly be.
So
And that's in the drafting.
Right. So, I mean, again, we get back to the Michigan Trust Code relies upon a qualified trust beneficiary as being sort of a heightened status of entitlement for information. And then we have all other trust beneficiaries who are floating around out there, either as vested or unvested remainder beneficiaries or contingent beneficiaries. And where do you draw the line and who gets information and who does not? Because we're dealing with, again, an expectation of keeping the affairs of a trust confidential and private. How far out do we go in revealing information? And that's one where, again, I think good observations. It would be helpful to draft to guide the trustee. This is who you must give information to. Everybody else, you can keep them in the dark. If they don't like it, let them file a petition with the probate court. I like that approach. Good topic. Other questions? We're beyond our time. Thank you all for coming. Thank you for listening, those who are there.